Good afternoon, everybody, and welcome to the weekly press briefing of the Kosovo Specialist Chambers, where we aim to provide journalists with an update on the latest developments at the court and the opportunity to ask questions. In the trial of Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi, on 26 March, the trial panel granted the prosecution's request for a witness to testify via video link based on health and security concerns. The decision became public on 4th April 2025. On 3rd of April, the trial panel granted a request by the prosecution to admit a witness statement in written form only and without cross-examination. The panel found that the statement was relevant, largely corroborated by other witnesses the defense had the possibility to cross-examine, and goes to proof of other matters than the conduct of the accused. On the same day, the panel granted in part a request by the prosecution to admit into evidence the written testimony and associated exhibits of 7 witnesses. The panel granted the request where it found that the evidence was relevant, authentic, and reliable, and where its probative value was not outweighed by any prejudicial effect. The panel rejected the request where it doubted the reliability of the evidence or considered it moot in cases where the said evidence had already been admitted into evidence at an earlier occasion. On 4th April, the trial panel granted in part a request by the prosecution to admit into evidence certain documents on the Neurodima operational zone, finding they are relevant, authentic, and not outweighed by any prejudicial effect. The panel rejected those items that, in view of the panel, lacked sufficient indicia of authenticity. In this case, a status conference has been scheduled for 23rd April to discuss the next steps in the proceedings. The hearing is scheduled to start at 10 in the morning. On 7th April, became public the trial panel's decision from 19th March to grant Mr. Thaçi a custodial visit on compelling humanitarian grounds after his father had passed away. The trial panel found that considering the close family link between the accused and the deceased, the fact that Mr. Thaçi's father passed away constituted compelling humanitarian grounds justifying Mr. Thaçi's temporary release for a custodial visit. However, in view of the panel, a custodial visit during the funeral and public commemoration events would have posed significant security concerns. The panel found that these risks could be appropriately mitigated if the visit took place after the funeral. The panel based their decision on the charges Mr. Thaçi is facing, including criminal offenses against the administration of justice for allegedly having disclosed secret information to unlawfully influence the testimony of witnesses. The trial panel also considered the necessity of modified conditions of detention, as it appeared that Mr. Thaçi provided non-privileged visitors with information elicited during the testimony of protected witnesses. The panel further recalled their previous finding that there continues to be a risk that Mr. Thaçi may obstruct the progress of proceedings and/or commit further crimes. In the case of Hashim Thaçi, Bashkim Smakaj, Fadil Fazliu, Izni Kilay, and Hayreddin Kuchi on influencing of witnesses, the appeals panel on 3rd April rejected grounds 1, 2, and 3 of the prosecution's appeal of the pretrial judge's decision on the confirmation of the indictment. The appeals panel by majority granted ground 4 of the appeal, finding that the third form of incitement provided in Article 32(3) of the Kosovo Criminal Code is applicable in this case. As such, the matter was returned to the pretrial judge to assess whether the evidence supports the confirmation of an additional charge initially rejected by the pretrial judge. On 7 and 8 April 2025, the pretrial judge ordered the continued detention of Hashim Thaçi, Izni Kilay, Fadil Fazliu, and Bashkim Smakai, finding that in regards to all four accused, there are articulable grounds to believe that they may flee, obstruct the progress of proceedings, or commit further crimes. The pretrial judge further found that these risks can only be mitigated through their continued detention. On 7th April, the pretrial judge rejected a request by the defense of Mr. Smakai to halt the proceedings against Mr. Smakai based on an interview with witness 2, which was only disclosed to the defense and the pretrial judge after the indictment had been confirmed. The defense was of the view that the pretrial judge would not have confirmed the indictment if she had had knowledge of this interview. The pretrial judge, however, found that the confirmation decision in regards to Mr. Smakai's criminal responsibility was based on several factors, and she was therefore not convinced that her knowing of the interview would have made a difference to her decision. The pretrial judge therefore concluded that the interview with witness 2 was a matter to be discussed in trial. In the case of Salih Mustafa, a decision by the single judge from September 2024 became public on 3rd April 2025 in regards to the payment of reparations. In the decision, the single judge takes note of the wish of one of the participating victims to not receive the reparation payment. Given that the victims in this case had not yet in full received their reparation payments, the single judge ordered the registrar to distribute the rejected amount among the other participating victims. However, he pointed out that reparation payments to individual victims can overall not be higher than the amounts allocated to each victim as outlined in the reparations order. That was all from me. If there are any questions, I'd be happy to respond.